Hello, I'm attorney Dan Marr in the Nashua law firm of Hamlin and Kerrigan, and today I'm going to be talking about gifts upon death without a writing. So in New Hampshire, how that happens. We have writings that are deeds where you have a joint tenants right survivorship, you have life tenants where there's a remainder interest, there's transfers on death in deeds. There's a new statute on that I've covered in another vlog. There's also, for bank accounts, you can do you can transfer upon death. You can have it in a trust for a person. You can have it as a joint account where it automatically goes to the person upon their death. There's also ways to deal with that, of course, in stocks and your retirement plans, all of that, but that's all in writing. I'm talking today about gifts that are argued to be done without a writing. Happens a lot in safety deposit box, but safety deposit boxes are lesser used now, but they used to be used a lot, where somebody would say everything in the contents of that the other person was giving to me, and that would be an analysis. The way New Hampshire works for gifts, if an actual gift without something in writing making it real clear, is donative intent, delivery, and acceptance. Those are the three things that you need for a valid gift. In that situation, you don't need consideration. You don't have to have a promise that you're doing an exchange of something. It is donative intent, delivery, and acceptance. Now, obviously, in a will, that happens through the process of the statute of wills and trusts, same things. But I'm talking about when somebody goes and says, I was supposed to get the art collection, I was supposed to get the coins, maybe they're in the safety deposit box or like. So first they argue that they have donative intent, the person that's now dead promised this, and they put whatever evidence they have if they're trying to go to court on this, if there's a fight about it. Delivery and acceptance is the tougher parts, because if the art collection is still at the dead person's house when he dies or she dies, or the safety deposit box still has the contents that's in his name, still has the contents of the valuable collection, delivery and acceptance are tough to prove. Sometimes people will argue that, look, he gave me a key to the safety deposit box, and therefore he was telling me the contents were there. I've argued successfully in court where if there was a key and it was just really, I argued that it was really for access to help this person so that you could help him out if he needed access to these contents of the safety deposit box, and in that situation the court agreed with me, and there wasn't delivery and acceptance. She claimed there was donative intent, but you didn't have the three elements you need: donative intent, delivery, and acceptance. So in those situations when you're dealing with a gift, somebody says, a relative of yours says, or maybe a neighbor says, he told me I get those. Go to a lawyer if you want to challenge it. Think about the value, of course, to see if it's worth the challenge. But just because they say the dead person told me I was going to have this, if you disagree with that, they still have to prove in court donative intent, delivery, and acceptance for a full gift. And that's a tough one, often when the property is still in the possession or was in the possession at the time of death of the person that's deceased. I'm here at Hamlin and Kerrigan, happy to help you. I'm at 603-883-5501. Our website is NashuaLaw.com, and you can contact me, or you can check out our website that has my radio show, the one from late 2014 through March of 2023. It was a weekly show. All these vlogs, which are quite extensive, and there's a lot of other information, including some blogs on there too. So please check out our website. Call me if you have any questions. I'm Dan Marr at 603-883-5501. Thank you.